Have you ever stopped to think about how we get rules for the entire planet? I mean, there's no world president, no global parliament, right? And yet somehow, countries mostly manage to agree on big things like trade, travel, and where their borders are. So in this explainer, we're going to unpack that fascinating puzzle. Where does international law actually come from? Let's dive in.
Right. This is the big one. This is the fundamental question. Without a single central boss, how do we maintain any kind of order? You'd think it would be total chaos, but it's not. The answer is a little complicated, but it all starts with understanding one really key concept. And that concept is the sources of law. Okay, think of it like this. If you want to bake a cake, you need a recipe and you need your ingredients. Well, in international law, the sources are basically both the recipe and the raw ingredients that lawyers and judges and diplomats use to figure out what the rules actually are. Now, I know what you're thinking. Okay, this sounds messy. Is there an official list somewhere? And the answer, maybe surprisingly, is yes. There's a foundational document that pretty much acts as the go-to guide for finding international law. And this right here, this is it. Article 38 of the Statute of the International Court of Justice. This is the closest thing we have to an official blueprint. It literally tells the world's highest court exactly where to look for the rules. You can think of it as the legal system's official cheat sheet. So Article 38 breaks it down for us into four main categories. You've got your international conventions. We usually just call those treaties. Then there's international custom. After that, the general principles of law. And finally, what it calls subsidiary or supporting sources, like court decisions and academic writings. So let's break down what each of these really means. We're going to start with the two heavyweights. I mean, these are the real bedrock of the entire system. They are by far the most direct and powerful ways that countries create binding rules for themselves. So on one hand, you have treaties. These are basically formal, written contracts between countries. States get together, they hash it out, they sign on the dotted line, and they create these explicit, legally binding promises. But on the other hand, you have custom. These are the unwritten rules. Think of this as law that just emerges kind of organically. It's not written down in one single document, but it grows out of how countries act over a long time, creating this shared understanding of what they're all legally supposed to do. And that is the million-dollar question, isn't it? I mean, it's one thing to sign a contract, we all get that, but how does just a repeated action, an unwritten habit, suddenly get the same legal force? Well, it turns out there's a very specific two-part recipe for that. For custom to become actual law, it needs two key ingredients. First, you need what's called state practice. That's the physical part. It just means that countries have to be consistently doing a certain thing over time. But, and this is a big but, just doing the same thing isn't enough. You need the second ingredient, the psychological part, which has this fancy Latin name, Opinio Juris. This is the absolute crucial belief by those countries that they're acting this way because the law requires them to. Not just because it's polite or convenient, but because they feel legally bound. And proving this belief, that is one of the biggest challenges in all of international law. Okay, so we've got our two main pillars, treaties and customs. But what happens when those rules are a little vague, or maybe there's a gap in the law? Well, that's when judges and lawyers reach for the rest of the toolkit that Article 38 gives them. And this toolkit has three main tools inside: general principles of law, judicial decisions, and academic writings. Now, think of these not as rule makers, but as rule clarifiers. They don't really create new law from scratch, but they are absolutely essential for interpreting the treaties and customs we already have and for filling in any of those gaps. So, general principles are these foundational legal ideas that are so common, you can find them in just about every major legal system on Earth. A perfect example is the idea that if you break an agreement, you have a duty to repair the damage. International law basically borrows these core concepts to make sure there are no weird legal black holes where no rule applies. Okay, this is a really crucial point. Unlike in a lot of national legal systems like the US or the UK, international court decisions are not strictly binding precedent. A past ruling is, highly persuasive, but it doesn't legally force a future court to rule the same way. Think of it like this. A past decision is a highly respected guidebook offering expert advice on the legal landscape. But it's not the official map. Only a treaty or a custom can be the map. It's really good evidence of the law, but it isn't the law itself. And finally, we've got the writings of the world's most respected legal scholars, what Article 38 calls publicists.
For hundreds of years, these brilliant thinkers have analyzed how states behave and what treaties say to help organize and explain all the rules. Their work doesn't create law, but it's an absolutely invaluable tool for judges and diplomats who are trying to make sense of it all.
So, we've seen the blueprint. We've looked inside the toolkit. But why does this collection of treaties and customs and principles actually matter in the real world? Let's take a look at how this whole framework really affects all of our lives.
I want you to think about the phone in your pocket or the coffee you drank this morning. Chances are they crossed several international borders to get to you. And that is only possible because of international conventions, like the rules of the World Trade Organization, which create a predictable framework for trillions upon trillions of dollars in global trade.
These sources are also absolutely crucial for keeping the peace. When countries have a dispute, they can turn to courts and arbitration instead of going to war. A classic example is the Alabama Claims Arbitration, where the U.S. and Britain peacefully settled this huge dispute over warships after the Civil War. It set this powerful precedent that, diplomacy and law can actually win out over conflict. And maybe most importantly, international law provides a baseline for human dignity. You have these landmark treaties like the Universal Declaration of Human Rights and conventions against torture. These establish global standards. They create a powerful moral and legal force for protecting individuals everywhere. So it might seem like a bit of a patchwork, a jumble of different sources. But the crucial point is that this system actually works. It creates a framework of expectations, of accountability, and most of all, predictability. In a world with no single ruler, these sources of law provide the essential grammar for global cooperation. And that leaves us with a really critical question for the future. As we face these incredibly fast-moving global challenges, think about things like AI or climate change. Can we really afford to wait for these slow, unwritten customs to develop over decades? Or will our survival depend on our ability to come together and write new rules quickly in formal treaties? The answer to that question is going to define the 21st century.